Land sale contracts and conveyancing. Land sale contracts are subject to the Statute of Frauds and must be 1. In writing, 2. Signed by the parties to be bound, and 3. Articulate essential terms identifying the grantor and the grantee, the interest to convey, consideration to be paid, and the description of the land. An exception is partial performance. A land contract sale outside the Statute of Frauds is enforceable against the seller if the buyer does any of the following: A. Pays all or part of the purchase price. B. Takes possession, and or C. Makes substantial improvements. So the land sale process. 1. You have a contract, which is an agreement to buy or sell land. 2. Escrow period, a transfer of funds through escrow. 3. Closing, escrow, completion to deed delivery. And 4. Conveyance, which is a successful deed transfer upon which property is conveyed to the new owner. Equitable conversion. During escrow, after land sale of a contract, but before deed delivery, buyer owns the real property, but seller owns personal property, the right to proceed to the proceeds of the sale. Seller holds legal title to the trust for buyer and the action against seller for claims arising before the contract. Any judgment against the seller is converted into an interest in sale proceeds. Judgment is not enforceable against the real property, so the buyer is protected. Risk of loss. If property is destroyed before closing through no fault of the parties, buyer bears the risk of loss in most jurisdictions. This applies even if buyer has not taken possession. Parties can contract differently. Seller must credit any insurance proceeds from loss against the purchase price. Death of a party. If buyer or seller dies before closing, rights to the contract pass according to the interest held. So seller's interest passes as personal property, so the seller's estate can sue for sale of proceeds. Buyer's interest passes as real property. Buyer's estate can sue for delivery. Implied promises in land sale contracts. So every land sale contract contains 2 implied promises. The first is a promise to provide marketable title. So promise that title will be free from risk of litigation upon closing. Defects rendering title unmarketable include acquired by adverse possession, encumbered by interest such as servitude, mortgage, future interest, but seller has a right to satisfy outstanding mortgage or liens with the sale proceeds, or zoning ordinance violations exiting at sale or existing at sale, and zoning ordinance violations. This can be waived by the buyer, not by the seller. The second is a promise to disclose and make no material false statements. So seller must not materially misrepresent facts or make false statements concerning property. Seller has a duty to disclose known latent materials, defects, which may be disclaimed if the disclaimer is clear and specific. New property. So seller builder is subject to an implied warranty of quality and construction. Remedy for breach. Buyer must notify seller before closing and give reasonable time for seller to cure defects. If seller fails to cure, buyer can rescind, file for damages, demand specific performance, or file suit to quiet title. Merger. If buyer fails to notify seller before closing, contract merges with the deed and the seller is not liable for contractual promises. Deeds. A deed passes legal title from seller to buyer. The requirements to be effective, a deed must 1, lawfully be executed, so deed must be signed by the grantor, reasonably identify the parties, contain a legal description of the real estate, and 2, delivered, it requires the intent to be bound by the conveyance. The title passes upon effective delivery. It cannot be rescinded. Present intent controls. Physical transfer is not required. Third party or conditional transfers. If a deed is transferred with conditions or via a third party, courts look at grantor's intent and whether she retains control to rescind the transfer. Acceptance. Grantee must accept the deed. Acceptance is usually presumed non-existent, void. Entity cannot accept the deed. So rejection by grantee is ineffective delivery. There are 3 types of deeds. 1 is a general warranty, which includes 6 covenants for title. 2 is special warranty, where the grantor assures that A, he has not conveyed the land to another, and B, the land is free from encumbrances attaching while the grantor owned the land. And 3, quit claim, which is transfers whatever interest grantor purports to have in the property. There's no covenants included, and the grantor is not even promising he has title to convey. General warranty deeds include 6 covenants for title. Note, these covenants concern conditions of legal title, not physical condition of the property itself. So present covenants only breached at the time of delivery are 1, season, whereas the grantor covenants that he is the rightful owner, has title possession, and that the deed covers described land. Right to convey is the second one. Grantor covenants that he has the right to convey. The third is against encumbrances, which is when the grantor covenants that the land is free from encumbrances, servitudes, or mortgages. Then there are future covenants only breached upon the third party interference with possession of grantee. So 4 is quiet enjoyment. So the grantor covenants that grantee will not be disturbed by third party claim of lawful title. Warranty is the 5th one, which is when the grantor agrees to defend against lawful claim of title by another or pay defense costs if the claim is successful. And 6 is further assurances. So the grantor promises to perform future acts reasonably necessary to perfect the title conveyed. A bona fide purchaser for value is one who purchases property for value. They give a pecuniary consideration without notice of prior conveyance or encumbrance. Note, whether a buyer is a bona fide purchaser is important in the context of recording statutes. So purchaser includes mortgagees for value. It does not include donees or devisees. It's not protected by recording statutes under the shelter rule. Notice, a buyer has notice of a prior conveyance by any of the following: actual notice, which actual knowledge from any source; inquiry notice, what a reasonable inspection of the land would reveal, regardless of whether a buyer actually inspects; record notice, knowledge from a routine title search; a previous conveyance properly recorded in the chain of title, not a wild deed. Then there are recording statutes. So if a prior conveyance or interest is not recorded, a subsequent purchaser or mortgagee may be protected under the recording statute. The level of protection depends on the type of recording statute. So notice statutes are a subsequent bona fide purchaser always prevails Whether or not she recorded first, a subsequent bona fide purchaser always prevails over a prior grantee who fails to record. So sample language is no conveyance or mortgage of an interest in land shall be valid against any subsequent purchaser for value without notice therein until it is recorded. So under a race notice statute, the first subsequent bona fide purchaser to record prevails, and the sample language is no conveyance or mortgagee of an interest in land shall be valid against any subsequent purchaser for value without notice thereof, whose conveyance is first recorded. Race statutes. First grantee to record prevails, regardless of whether buyer is a bona fide purchaser. For example, non-bona fide purchasers who record first prevail over bona fide purchasers. Sample language is no conveyance or mortgagee of an interest in land shall be valid against a subsequent purchaser whose conveyance is first recorded. Issues can arise with recording statutes and chain of title. So one issue that could arise is the shelter rule. And this is one who takes from a bona fide purchaser will prevail against any interest the transferor bona fide purchaser would have prevailed against, even if the transferee had actual notice of a prior conveyance. So this protects donees or devisees of bona fide purchasers who cannot qualify as a bona fide purchaser and would not otherwise receive protection under notice or race notice statutes. Then there's wild deeds. This is a recorded deed unconnected to the chain of title in a grantor-grantee index system. This is due to a clerk's filing error or a failure to record a prior deed. A record notice cannot be derived from a valid deed. A wild deed cannot exist in a tract index system. Estoppel by deed. A grantor who conveys title to land he does not then own is estopped from subsequently acquiring the same land. Title automatically passes to the benefit of grantee. It prevents one from conveying land they do not own and later validly acquiring, so through a will. Most real property sales are negotiated by real estate brokers. So seller's agent, who is the listing broker, is a broker who obtains listings from the seller, engaged by the seller to assist in sale of property, has a fiduciary duty to seller, earns commission from sale of property once the sale closes. Seller's agent may still earn commission if the sale fails to close due to seller's fault. So the seller backs out. And then the buyer's agent or selling broker, the primary relationship is with the buyer. It shows buyer potential properties buyers may purchase, typically compensated by receiving a portion of listing broker's commission. So it gets paid out of seller's agent's commission. In common law, it owes a fiduciary duty to seller because buyer's agent is technically a sub-agent of the seller's agent. In modern statutes, it requires a separate agreement between buyer's agent and buyer, and buyer's agent owes fiduciary duty to buyer but no fiduciary duty to seller. Then there's a duty to disclose. Agents have a duty to disclose material information about which they have actual knowledge.